Shweta ma'am.
Hello, sir. Good evening.
I think we have some glitches. I'm not able to see ma'am. Just wait for a few seconds, sir. I think, yeah, she's back. Ma'am, I have given you option to unmute.
There is some network issue.
No problem. We'll start. Yes, ma'am. Good to go.
Am I audible?
You are audible, ma'am.
Am I audible?
You are audible, ma'am. Ma'am, you are audible. You can go ahead. Shweta ma'am, you are audible.
Maybe some network issue.
Yeah, there is a network issue, sir.
Network issue.
Just wait for a few seconds, sir. I think.
There is some network issue. I need to change the place.
That's okay, ma'am.
I'm extremely sorry. So I was introducing the speaker. Dr. Kantikar is a renowned medical law consultant and former member of the National Consumer Disputes Redressal Commission, New Delhi. He holds an impressive combination of qualifications, that is MD in pathology and PhD Commission, 2 full terms, totaling 10 years from March 2013 to June 2023, judgments on consumer disputes, including over 1,000 landmark decisions on medical negligence, many of which have been upheld by the Honorable Supreme Court of India. In recognition of his outstanding contributions, Dr. Kantikar sir was honored with the prestigious Karnataka Rajyotsava Award in 2021, the second highest civilian award conferred by the government of Karnataka. Beyond his judicial role, Dr. Kantikar sir has significantly contributed to medical ethics and law as a resource person and faculty at Eminent in and also various national law universities and numerous national and state medical law conferences. He also contributed beyond the courtroom. He established and served for over 25 years as a consultant pathologist and academic leader in medical education. Currently, Dr. Kantikar sir continues his mission as an associate professor of pathology at the Subbaiah Institute of Medical Sciences, Shivamogga, and as a medical law advisor and mediator, specializing in medical negligence, health insurance disputes, and consumer litigation. On behalf of Advocates Association Bangalore, sir, I welcome you to this webinar program.
Thank you, madam. Thank you.
Once again, on behalf of Advocates Association Bengaluru, Advocates Academy Bengaluru, and my personal behalf, sir, I extend a very warm welcome to you. I also welcome our treasurer, Srimati Shweta Ravishankar. I also take this opportunity to welcome all the participants. Now over to you, sir.
Thank you all, and the members of Advocates Academy Bangalore, the my seniors, the professional colleagues, Advocate Vikram, he suggested me to just have a enlighten about the medical negligence and the new Consumer Protection Act 2019, which was enacted on 20th July 20. It came in force from 20th July 2020. Still, there is some confusion amongst the few advocates, even the district commission members and district forums also. So, to switch over to the new Consumer Protection Act, before that, I will discuss few points on medical negligence, and my speech will be focused on medical negligence under Consumer Protection Act 2019. I am sure you all are aware of Consumer Protection Act 1986, which was previous act, and it was repealed and new act has come in force. So one thing is the misconception whether the medical services, just I want to, whether the medical services are excluded from the Consumer Protection Act in the new Consumer Protection. Remember, it was in the 1986 Act and it is not excluded from CPA 2019 because it is categorically held by Honorable Justice D.Y. Chandrachud that service is wide enough, definition of service is wide enough. You may be aware the one writ petition was filed in Bombay High Court and that was dismissed by Bombay High Court. Same was challenged before the Honorable Supreme Court by the doctor's body, and it was again dismissed with the cost of 50,000, and it was made clear because you are aware the VP Shanta's judgment, three judges bench judgment, it prevails unless some other judgment or some other bench, larger bench sit and decide, then and then only it is possible whether the medical services are under purview of Consumer Protection Law or you can delete or not. Otherwise, the Parliament, if the Parliament wanted to exclude, the Parliament would have said expressly that medical services are deleted, but that has not happened. Therefore, medical services are under Consumer Protection Act. Now, the word is negligence. What is negligence now? Everywhere we say negligence. Sorry, negligence. What it is? Actually, meaning of negligence, it is the act of omission or act of commission. So I have to talk on for the advocate's point of view, because you are contesting or you are taking the cases on behalf of the patient also, clients are patients, or the doctors also, or the hospitals. So now you have to establish, if you are from complainant, you have to prove there was act of omission or commission from the doctor. And if you want to defend, then the converse, you have to show there was no any negligence. That means there was no omission or commission. The doctor has treated, the hospital has treated as per the reasonable standards, and we'll come for that reasonable standard, what it is. So you know the doctor's liability for the wrongful act. Definitely everyone is liable under law for the wrongful act. But doctor's liability, the patient can exercise his right, the liability through 4 channels. One is criminal liability. Second, civil liability. Under civil liability, there is a contractual. So there is a contract. We will perform the operation. The package will be there. The cataract surgery will be performed within 20,000. This is the contractual obligation of the hospital or the doctor. If there is a breach, yes, the patient can approach through civil court about for the contractual liability. Then I have shown this is the CPA, Consumer Protection Act 2019. Previously it was 86, and PRB means Professional Regulatory Bodies. For the allopathy, professional regulatory body was MCI, now it is NMC, National Medical Commission. Ayurveda Council is there, Homeopathy Council, and so on, Dental Council is there. There are many professional, and likewise NMC, National Medical Commission. Every state had state medical councils, where initially the patient or the aggrieved complainant can approach criminal court, civil court, under contractual. He can file the consumer complaint also. He can file the complaint before the professional regulatory board. And now another is there. He can approach Human Rights Commission also. Now there is a huge shift. Previously, Vaidya Narayana Hari was the saying. Now it has gone. Nobody believes, and no, there is no such. Why there is not Narayan now? Why it is? It is a shift from the current doctor-driven to consumer-driven healthcare. Consumers are more aware. We have to think whether consumers are aware. Consumer here is the patient. The patients are more aware of their rights, or whether the doctors are failing in their duty. There are two things. Why there are more cases? Definitely something is ups and downs are there. Then the digital or health apps are available. The patient will Googleize everything and he will approach the doctor. So in nutshell, there is a changing doctor-patient relationship. I told the changing doctor relationship is Vaidya Narayan. It is not there now. It has absolutely changed now. You can see this study I have done this study and collected the data 2010 to 16 for my PhD. You can see the nearly more than 10 to 15 times rise. These are the original complaints filed before the National Commission. So you can think over the gravity. It is a three-tier system: district, forum, state commission, and national. These are the cases, original complaints. I have not taken the appeals or revision petitions. Definitely the number was more. And there was a study from National Law School of Bangalore. There is a 400-fold rise in the medical negligence. So there is a rising trend of medical negligence cases. Either doctors are failing in their duty, or the patients are more aware of their rights, and they are questioning the doctors also. Now, who can file the complaint? I'm sure you all are aware. You are so just glance the slide, and the patient himself, if he is alive. Then the registered consumer organization, there are voluntary organizations, state or central government also can file, and the legal heir or legal representative. Now this is very important slide, whether you are from complainant side or defendant side. Remember 4D. 4D is applicable for both. If you are a complainant, you are representing the complainant, then complainant has to prove all the 4Ds. And the doctor has to disprove all the 4Ds. What it means? The essence of medical negligence, it revolves on all the 4Ds only. You have to establish there was a duty towards the patient. That doctor has duty towards the patient. Suppose if he is orthopedician and the patient is of the gynec or pregnant woman, so definitely the orthopedician has no duty towards that lady, whatever it is, unless it is an emergency. If she is in the labor or emergency bleeding, definitely he has duty. But in the routine practice, you have to establish there was a duty towards the patient, that doctor has duty or that hospital has duty towards the patient. If there is a duty, if you establish yes, there was a duty, then what he has done, there was a deficiency in his duty. Suppose the patient comes with a chest pain and the physician is sitting. Yes, physician has duty towards the patient to examine. He will definitely examine the patient, and without ECG, he will advise take few tablets. You have just gastritis, go. There is no need of ECG. But patient goes to the house and he will land in myocardial infarction or heart attack and dies. So that is the deficiency duty. What deficiency you have when the patient is of chest pain? What is your duty? Examine, then take ECG. That is the reasonable the law expects. Then that deficiency, now that deficiency should result directly in the injury, that injury. Suppose patient, he has not done ECG, he has given the medication, but after few days he suffers heart attack. He cannot say that there is because that time he failed, he just prescribed me antacid and that has resulted in this heart attack. No, there should be direct nexus from that breach to the injury. Then fourth is damage. Definitely, if you prove all the 3 Ds, definitely there is a damage, physical damage, mental damage, trauma in the family, and then the complainant will succeed. If you prove all 4 Ds, he will succeed in his case. Conversely, the doctor has to prove. Doctor has to prove that I have no duty towards that patient, or I have done my duty very carefully. I have done my duty carefully, and there was no deficiency. Doctor has to defend in this way. What are the instances of medical negligence? Where the doctor, how the cases will come? The error, I have given the chart, tabular chart, error and example, diagnosis or evaluation, missed diagnosis, then the medical decision making, premature discharge. You are coming, a lot of cases are coming across, I am sure. If the patient is serious, the hospital will discharge. It is a premature discharge. Then the treatment, if there is a treatment, unnecessary waiting, then the wrong medication. This is especially in the cases of insulin or diabetic patients. This happens. The wrong medications, wrong dosage. Because doctor will say, you take 4 units of insulin. Erroneously, if he writes, or the junior will write 40 units, then definitely it is a high dosage. Patient will land in hypoglycemia and he may die, or he may show comatose condition. Then inadequate supervision, definitely it is, if the patient growls, the patient come with the complaint, nobody attended me, I was in the ward. Patient relative will complain. In the ICU, no staff nurse was there. This is the point from where litigation will start. And the faulty communication. Yes, faulty communication, it is most of the doctors, most of the senior doctors, they just write the prescription, go there, take the medicine, or ask the sister. This is not the thing. This causes some eruption of the complaint and other. Failure to convey the information also. Failure to convey the information. You have this disease, you explain what happened, what you want to do. Then the procedural complication and faulty techniques also. These are all the instances where the medical errors occur, and these are the points of litigation. It will start, initiation of litigation will start here. Again, same, you have to prove proficiency, procedural error or failure to monitor, same, it is the same slide. Now, some crucial points in medical negligence I want to highlight: the doctor-patient relationship. If the doctor-patient relationship is good, I won't think patient will come and file the case against any doctor. Many times what happens, doctors, whether they are busy or whether they are the hectic schedule or anything, sometimes there is a rash speech or rash appearance that will create the patient or his relative. They definitely they will. This is not good, and this evoke the litigation. Then what is the reasonable standard of care or practice? Just I gave one example. If the patient comes with the chest pain, what is the reasonable care if the doctor is the MBBS? If your client is MBBS, you can depend he is a MBBS. Whatever possible he has done, he has examined. Because he don't have ECG, he has referred to the cardiologist. But he has not referred the cardiologist. He is a physician, family physician, simple MBBS. But he just examined and nothing. His duty is just pain, refer cardiologist when he can't do that. This law expects, because courts expect reasonable standard of care. Court never expect, oh, he had chest pain, why you are not admitted in ICU? When I am MBBS, there is no ICU. How can I? But what you have to do? You have to refer the patient immediately or arrange the patient to shift to cardiac center. Tell the relative. This was your duty. This was the reasonable standard of care. Then the doctrine of consent. Most of the cases in the consumer court are filed on the consent. Most of the patients, they say, doctor ನಮಗೆ ಏನು ಹೇಳಿಲ್ಲ, only he took signature, the hospital or nurse came, took signature on the blank paper or blank printed form. So this is the version, this is the allegation or version, whatever it is. But how to prove? Let us go. Doctrine of consent. What is consent now? Consent is a self-determination. Every person has a right of self-determination and personal autonomy to decide what shall be done with my body, his or her own body. The second line in red is very important. Signature on dotted lines goes long way in the litigation. This is very important. This slide I highlight in the medical, in the doctor's forum, because of the hospital, it will take signature on the printed form with the dotted lines, because it will not suffice your care what you have done. Whether this, if it is a dotted line, signature on dotted line, how the doctor will prove that he has told everything to the patient and took the signature? No name, no name of doctor, no name of patient, no diagnosis, nothing, only signature of the patient. So this is very bad. And if you come across such a case, definitely it is a winning case in the medical. Most of the litigations are informed. What is informed consent? We say consent many times during argument, before our bench also. Many senior lawyers, senior counsel, they appeared. And no, sir, they have taken the consent. Then I have to judge whether it was informed consent. What is informed consent? The law expects informed consent, not implied consent or just mandate, just verbal consent is not acceptable in the court of law. What is informed consent? Informed consent is you means doctor has to inform the benefits of the treatment, risk of the treatment, any alternatives are there or not, he has to explain. And whether there is no treatment also, he has to explain. And finally, document that what he has explained. This is informed consent. If you just tell, sign here, you will, I am performing this operation and all the complications are explained. No. Informed consent, you have, if you are performing, if the doctor is performing the seizure operation, or if he is performing fracture reduction operation, fracture reduction, he has to explain there may be malunion, there may be infection, the rod may cut, you may suffer pulmonary embolism. All these complications, related complications, you have to explain. Or whether there is any alternative. Without rod, you can keep, or with nails, you can treat. So all this comprise informed consent. So informed consent has very much role. You are aware the Samira Kohli judgment in the last para of Samira Kohli, Honorable Supreme Court lay down nearly 9 to 10 points what constitutes consent and informed consent. Samira Kohli is the case versus Prabha Manchanda, Dr. Prabha Manchanda. Now everything is okay, but the case when it comes to the Consumer Commission or any court, civil court or any, how will you prove? Or how the patient or how the doctor will prove that they have done correctly or not done correctly? So there are records. So you have to call the records. Medical record is the property of the patient. And as per the NMC regulation 1.3.3, the medical records, the hospital shall provide medical records within 72 hours of the application. And they have to provide the application should be from the patient or his close relative. The hospital's duty, it is hospital's duty. The patient or anybody, the relative has to apply, close relative, near relative, and they should get within 72 hours. This, remember, so on this only you can approach the professional regulatory body or your state, Karnataka State Medical Council. They have not given me the medical records for a week or 1 month. So the action will be taken from or they will pass the direction, issue the medical record. So what are the types of medical record? It is again, sometimes the patient will come with the discharge summary. Namge hospital in No, if you want to prove the case, you need entire medical record, admission details, investigations, clinical examination, progress notes, because this will be referred to expert opinion also. Sometimes for the expert, you have to refer such thing to the expert opinion also. So that time only the discharge summary will not help. Then what you have to see the crucial points, whether chronology, the medical records are chronologically maintained or not, whether the referral note is proper or not. Because many times I have seen in before our bench, refer to higher center. What it means? Refer to higher center means what? In Bangalore, refer to higher center, there are Nimans, Manipal Hospital or Kidwai, whatever it is, or Bangalore Medical College, anything, Victoria. But if somebody is refer to higher center means they have to specify where you are referring, why you are referring, what treatment you have given. If the referral note lacks all this information, definitely this will fall in the deficiency of service and failure of duty of care. Then the discharge note is the entire summary what happened during the hospitalization. So discharge note, you as advocates meticulously screen the discharge summary and you will get something to prove or disprove your case. Then the confidential information. There are some diseases which are confidential because patients may file the complaint. The hospital has breached the confidentiality. They have disclosed, I am HIV positive. They have disclosed HIV definitely. You can't disclose to someone, either patient or his parents or his wife or whatever it is. Other than that, no friends, nothing. That will attract the liability. And Then many times in the red, I have highlighted the records are corrected. Medical records are corrected, but scribble or by blade, they will. This is wrong. If such records are there, definitely the commission will infer there is a tampering, or they may send for forensic study, or whether tampering ink is changed or anything. So just look for this. So then importance of medical record also, the RTA, City Act, and workman compensation, even for the criminal cases you need insurance purpose. And medical record acts as a legal document for the patient also, for the doctor also, for the proper billing and other. So good medical record. This is the good medical record. This is not just glance the slide. There should be 6C, remember, clarity, completeness. Because some records are incomplete. They just write and leave it. This is not a record. If such records are there, definitely court will take adverse inference. Then concise, chronology and confidentiality. See this last. What the court expects, the commission, the medical record should be neat, legible, timely, accurate, with the professional tone. Now, who is liable? The question is, who is liable? Doctor, hospital, or others? The concept of vicarious liability, you all are aware. So, if it is a contract of service, it attracts vicarious liability. If doctor is working under some hospital and there is a negligence, that time, if even the doctor is negligent, he has done some wrong act, wrongful act, along with him, the hospital will also penalize. It is known as vicarious liability because the earnings of the hospital is coming from the doctor's act. So both are equally liable, or usually the doctor will be less liable, vicarious liability will be more on the hospital. Second is independent doctor or independent contractor. It is a contract for service. If I have a clinic, it is my hospital, solo hospital, anything, that time I am responsible for the wrong which I have done with the patient. The liability, entire liability will be on the doctor individual. There's any questions on medical negligence? I welcome any questions.
I repeat, if there are any questions pertaining to medical negligence, I would request the participants to hit on the thumbs up button or raise hand button so that I would unmute them and you can personally pose your question to the resource person. Or you parallelly, you can also put it across in the chat box so
Yes,
that
yes.
I would be reading that to the resource
Yes,
person.
yes. So just we'll move to new provisions. What are the new provisions with reference to medical negligence, concerned with the medical negligence? Because Consumer Protection Act is vast. It is goods and service. I'm not touching the builders and the insurance or any deficiency in service from the offices and other things. I'm restricting it.
Sir, one second, if I may stop you for a moment.
Yes,
I have
yes.
one question from Mr. One second, sir. I'll just open. One second. Just bear with me for a moment. Question is from Mr. Nagaraj Rao. Whether medical council decision is binding on the consumer commission?
Yes, this is very important. See, the commissions or any expert opinion, they are not binding on the consumer commission. Medical Council of India's opinion is not binding on because they are professional regulatory bodies. They decide professional misconduct. They won't decide the medical negligence. And they have no power to penalize or punish also. And that The courts are the final. They can decide, they can weigh the evidence and other thing, and they can pass the order. That order is not absolutely binding.
And we have one more question from Ms. Vijeta, though slightly digress from the main topic, but still something pertinent. I would read it out, sir. Can HIV position or the status of the patient be informed to the spouse?
HIV status.
Though it has nothing to do with the topic, but it could be of some relevance, especially in the matrimonial cases, etc. If a person is suffering from HIV, such as it is barred by the right to privacy, and it could
no. You just refer the case, Mr. X versus Y versus Z, or X versus Y is the case, Honorable Supreme Court, because they kept the name of the party is hidden. Y versus Z or something is there. In that, Supreme Court categorically told, if it is a life-saving or if it is a beneficial for the others, the disclosure of the doctor is not an offense. The case was, he engaged with one marriage proposal was there. He was in the military service, or he got a military service, and during his medical checkup, they detected HIV positive status. The doctor was aware that this fellow engaged, and he knows the parents of the girl, and he intimated that, see, this boy had so and so, you think over. And that time, that person, he lost the job, and he approached the court, and the matter traveled up to Supreme Court. And Supreme Court said, if it is in the larger interest or in the health and other, then such disclosure will not affect, we will not attract any liability. It is not a breach of confidentiality.
Yes, sir. There's one more pertinent question. Before that, sir, you mentioned about a case law. I would just read it out for the benefit of the participants. That is Samira Kohli versus Dr. Prabha Chanda, decided on 16/1/2008 by 3 judges bench of the Supreme Court, reported in AIR 2008 Supreme Court, page 1385. I repeat, yes. Samira Kohli versus Dr. Prabha Machanda, AIR 2008 Supreme Court 1385. We'll take up the last question on this medical negligence before we move on to the next topic by Mr. Mallikarjun. Medical negligence cases are have lot of intricacies, but how the commission would decide only on the basis of few documents?
No, I could not get your question. What
medical
is the
negligence? When the commission is deciding it, it would be based on a few documents alone, because there is no provision of cross-examination. Therefore, merely based on a few documents, how can the commission come to the conclusion of medical negligence is the question.
No, there is a provision for cross-examination is there. It is wrong that there is no provision for cross-examination. One thing, they will not call the doctor and take the evidence in presence, but interrogatories are to be filed. Yes, there is absolute provision is there. Both the parties, the court will permit, commission will permit to file the interrogatories, take the replies and the argument also. And the medical record, it will speak everything, what the doctor has done or what doctor has not done. If something is concealed, the patient complainant has every right to ask that document. If it is a vital, suppose operative notes or monitoring of the operation, if that document is missing, definitely it will go adverse against the hospital or the doctor. So there is a provision of cross-examination.
So there is a provision of cross-examination. There is also provision of defense evidence too.
Yes, you can ask for the expert evidence. You can ask for the interrogative cross-examination. File the application for.
Sir, you are not audible for a moment.
File the application for cross-examining the doctor. Court will give you the permission. They will pass the order. file the interrogatories, reply the interrogatories within so and so date. Court has the power to send the commissioner also to take the version of the document.
Right. Thank you, sir. I think we are done with most of the questions. You may proceed with the next facet of. I think we have somebody, Advocate Sneha Yadav. I'll unmute her. She has a question.
No, let them, even later on, my email ID will be there, or phone number, they can communicate.
We'll take up only this question, sir. Later we'll proceed with the.
Yes.
One second. Advocate Sneha, she has raised her hand, so I'll be unmuting her.
The new provisions under Consumer Protection Act 2019.
Yes, madam, I have given you unmute option. You may quickly post the question. Advocate Sneha. I've given you option to unmute. Yes, please.
Shall I continue or?
One second. She's asking her question, sir. Advocate Sneha.
Yes.
Madam, quickly.
Yes. How can you know that?
You are not audible, madam.
Hello.
Hello.
Can you hear me, sir? Now? Hello.
Yes.
Sir, I have a question. How can we prove that the hospital also involved in the medical negligence?
How to prove hospital also involved in medical negligence?
Yes, sir.
See, the concept of vicarious liability is there, number one. Secondly, suppose oxygen cylinder there is a deficient oxygen cylinder, or non-provision of blood, non-arrangement of suppose the operation theatre is infected. The operation theatre, if there is an infection in operation theatre, and after operation, if the patient develops infection, now you have to prove the infection came from the OT, operation theatre. In that case, the entire liability of the hospital to maintain the sterility. If the doctor commits wrong, he will be liable. But if he is working in that hospital, again, the hospital is liable on his behalf also. Whether hospital negligence of hospital is there or not, the concept of principle of vicarious liability is applicable.
Yes, sir. Now you may proceed with other facet of the webinar.
The new provisions under Consumer Protection Act, it is already 5 years over, and I'm sure you all learned advocates are aware of. There is a deemed admissibility. If the complaint is filed and the commission, district commission or so, if they won't take on board for 21 days, unless there is any lacunae defects or defects to be cured. But after curing the defects, after 21 days, it is deemed admitted, because admission hearing should be there. If they won't take, it is deemed admitted. Then there is a change in pecuniary and territorial jurisdiction. There is change in pecuniary and territorial jurisdiction. I will tell about the both in the next slide. Ease of approaching the commission. Filing from the place or residence of work. E-filing is possible. Video conferencing is available. Then the review powers are given under this new act. Review to district and state commission. Previously, it was not there. Review, they have to reach national commission in the previous act. Then appeal only on the question of law. At second stage, there is no revision petition now. Second appeal is on the question of law only before the National Commission. Yes, what is pecuniary jurisdiction? Pecuniary jurisdiction under this it is based on consideration paid. In the previous act, it was based on compensation claimed. If somebody, complainant is claiming compensation up to 20 lakhs, he has to go district, up to 1 crore state, and more than 1 crore national. Now it has changed. It is based on consideration paid, how much he has paid. So for the district commission, less than 50 lakh, if he has paid for the services or goods or anything, he has to approach district commission. 50 to 2 crore, state commission, and beyond 2 crores, if he has paid, then he has to go to approach national commission. The example is here. The patient pays a doctor or hospital rupees 3 lakh for the treatment, wants to file complaint for alleged medical negligence to claim compensation of 2 crore. See the scenario. So in the previous act, 2 crore means directly he has to go to national. But now it is not there. He has to file before the district commission. So now, therefore, all the medical negligence cases will be before district commission only. Remember, this is very important. All medical negligence cases be filed before district commission. I won't think anybody, any patient will pay more than 50 lakhs. And then only he has to approach state commission. Then another is territorial jurisdiction. This is again important to understand. In the new act, the provision is provided, whether it is good or bad. Doctors are telling it is bad provision. But where to file the consumer complaint? The patient has a choice to filing the complaint either at the place where he or she resides or works, or at the place where the service provider, means doctor reside or works. So patient has two choices. Either he can file where the doctor is, or he can file at his place of residence or work. Example, if the urologist from Bangalore perform any surgery to the patient from Bihar, the patient develops complications and decides to file a complaint against the doctor. So he can file the complaint in Bihar District Commission or in the District Commission in Karnataka or in Bangalore. The operation was in Bangalore. So he has a choice. He can, if he want to trouble, he will file in the Bihar and he will call the doctor there. But now the online facility is there, so there is no need to go. Virtual courts are there, and you can send the evidence online, affidavit of evidence, anything. And for the argument, if you want, you can argue online or you can go there. Doctor can go there. There is a provision of mediation also. Under this act, provision of mediation, the certain matters, particularly medical negligence, when the mediation is not available in medical negligence, if it is a grievous hurt or the death case, if the patient died of medical negligence, then there is no scope of mediation. Therefore, it is imperative, very important for the doctors, if whether to go for mediation or not. So some other provisions I have not mentioned. Other means provision for review I have told. Then new Consumer Protection Act. It is dealing with unfair contracts. Then misleading advertisements, e-commerce cases. Now new provisions they have provided that I have not taken here. And now there is a product liability concept is also in the new act. Then the product liability, then CCPA is there, Central Consumer Authority is there. They deal with misleading advertisement and they can stop. They have power, suo motu, they can initiate the inquiry also. So this is about new Consumer Protection Act. I have briefed, but these are very important provisions for the complainant or for the consumer, overall consumer. So now we will move to some few interesting cases I have taken. Res ipsa loquitur. See the picture. Res ipsa loquitur means the thing will prove itself. There is no need. The seizure is inside the abdomen. X-ray is showing seizure is inside the abdomen. This is frank negligence. There is no need to any evidence or anything. It proves itself. The article left in the patient's body, operating on the wrong side of the body. You know, the one heroine's mother, she was operated in US, wrong side of the brain. Sridevi's mother, I think Sridevi's mother's brain surgery was done. They wrongly operated on other side. Lesion was on one side, they operated on other side. Not operating in time also. If the patient is need emergency, operation is imminent, but not operating. So there is no need to prove. The patient was rupture abdomen, rupture appendix, or ruptured ectopic pregnancy. Immediate operation is needed. Then IVF cases, in vitro fertilization cases, many mischief, many things happening in the IVF centers. So straightway you can prove the and surrogacy also. Surrogacy and IVF is very vast topic. So remember, under these circumstances, the principle of res ipsa loquitur will be applied. This is one case which was decided by our bench in 23 April. This Woodland Hospital, one software engineer, he was diagnosed non-Hodgkin's lymphoma. It is a cancerous tumor of the lymph. And some protocol was suggested by the Tata Cancer Hospital. Patient went to Calcutta and took the chemotherapy there in Woodlands. But what happened, you see, the anesthetist injected vincristine intrathecally. The vincristine should be given intravenously. Intrathecally means in the spinal cord. In the general term, in layman's term, it's in the spinal cord. By wrongly, he injected the injection intrathecally. Suddenly, patient deteriorated, immediately airlifted within 2 days and died within 1 week. And he filed a complaint for 3.1 crore. We held the negligence and awarded 60 lakh. What are the essence here? Remember 4D, what we see in the previous slide. The oncologist did not follow the instruction because it was his duty to follow the instruction of Tata Memorial Hospital. But he was not present when chemotherapy was given. And OP3 means anesthetist who blindly gave the injection vincristine intrathecally. It was utter failure, carelessness, and dereliction of duty of care. This is another case. Again, Tata Memorial Hospital. It is a contributory negligence. Many times you will get the patient, there was a negligence, but what doctor will say, I have advised the patient, but he did not come for the follow-up. Yes, this is the negligence of patient also. Not going for follow-up is the negligence. In this case, the biopsy was done of the esophageal end, and the patient did not wait for the report. And doctor also did not wait for the report. Doctor said, okay, it appears to be a cancer, you start chemotherapy. He took chemotherapy cycles, 4 cycles, but after 2 months, there was no improvement and he got the report. Patient came to the hospital and got the report. And it was TB. So now who is wrong? It was the patient's duty to collect the report within a week and show to the doctor, but he passed the time for 2 months, and doctor, without investigation or without confirming malignancy, started chemotherapy. So this is the clear case. So we held the negligence, but compensation was reduced to 50%. This is very landmark judgment of Supreme Court, which held to hold negligence. The medical for the medical negligence, higher threshold limit must be met. What it is, what it means? The court expects reasonable standard of practice, reasonable care. Court never expects higher standard of. Court never expects the corporate hospitals like in Bengaluru or Apollo or anything from the other hospitals. So what reasonably necessary for the patient, you have to do that. If you fail to do that, that minimum also, definitely there is a liability. Sorry, this. So, any questions now?
I would again repeat, if any questions to be posed by the participants, they can hit on the raise hand button, or they can also parallelly drop in the chat box, so that I would be posing those questions to the resource person. They are requesting for the slides to be shared to them post the webinar, sir. You're the
Slide, you can share the slides.
Yes. We'll convert it into a PDF file and we'll share it with the participants.
You can save in PDF and circulate.
Yes,
and
sir.
If anybody had any query or any clarification, further clarification, or I am available here. I am in Shimoga, Delhi, and Bombay also. I have to visit.
We have the president of DCDRC, and the question is whether complainant or the opposite party has burden of proof in medical negligence. I repeat, whether complainant or the opposite party has burden of proof in medical negligence.
Yes, burden of proof is initially on the patient. What patient will say, I was taken in the operation theatre. They have taken the consent. They have done the surgery. This is his duty. This is the proof. Only it is available with him. Now he told all those things. What happened to him? Now the burden will shift on the doctor. The shifting burden of proof shifts on the hospital or doctor, that inside the OT what happened nobody knows except the doctor. That burden, that I have done correctly, I have not done wrong, that burden is on the hospital. The burden of proof shifts. Definitely it shifts. It is not absolutely with the patient only. He has done his duty. He has told so and so, they have prescribed, see, these are the documents, these are the things, I know this much. This is his burden. He has done his duty. Now its burden shifts on the hospital. This is the principle.
So primarily the doctor has to show that duty of care was executed by him with due diligence.
Yes.
And sir, there's a very good question by Mr. Nagaraj Rao. Whether multiplier method is allowed in medical negligence?
No, multiplier, you can refer the Kunal Sahab judgment 2014. Citation, I am not remembering, 100.
We'll share it with them.
2014, 100 SCC something is there. The Honorable Justice Gopal Gowda, he has given elaborate clarification. In the medical negligence, you cannot apply strictly the multiplier method or the and other calculations also. There are many judgments on multiplier method, because there is a pecuniary and non-pecuniary damages, the mental agony and other thing. It cannot be judged by the multiplier method. The Kunal Shah judgment is the guiding force on the compensation.
Kirtan, parallelly, I would request you to share that citation with the participants on the chat box.
Yes. That citation,
my colleague
citation, I think in the last slide it is there. I will show that slide. See here. Kunal Shah versus Amri Hospital 2014 384.
Now the slides are off, sir. I think we are not able to see the slides.
SSC 384 2014. Kunal Shah versus Amri Hospital.
Kirtan, nevertheless, you please share it with the audience on the chat box. So the next question is, surgery has been done in abdomen, whereas the doctor has made a scar on the patient's face. Does this come under medical negligence? Is a question posed by Shweta.
Surgery made in abdomen.
Surgery has been done in abdomen, whereas the doctor has made a scar on the patient's face.
No, that is negligence. No, how he has done the surgery. Surgery on abdomen and scar on face, it is maybe accidental. Sometimes the knife, cutting of the knife or on the face or the needle injury. These are the injuries. That is wrong. Patient should be taken care because patient is in your hand. You have to deal with the patient. That is absolute gross negligence also.
Right, sir. Madam Smita Prasad has a question. Perhaps as a doctor, you would be able to answer this. Sir, when there is a criminal case also running and also case at KMC, why should the doctor be left to practice unless proven innocent or guilty? That means that two cases are parallelly running, one before the Karnataka Medical Council and another before the perhaps the criminal court. Why should his license be suspended is perhaps the question. Unless
No. See, unless the decision from medical council, because
yes,
unless they pass the order, till then he can practice. Where is the bar? It is not a bar. The case, consumer court case is going on. The state KMC case is running on. KMC has not passed any order. Then who told doctor has to close his clinic and keep quiet? Where is that? Then in any statute or anywhere, it is not written also. Unless there is any order of stoppage of that profession. If the KMC say your name is deleted or you should stop practice for 2 months, from the effect will be from that day of the order. But when the litigation is going on, there is no bar.
yes, sir. I think we have picked up almost all the questions. I think she has sent one more question in continuation of the first one. The hospital fired the doctor to get away from responsibility and yet he is practicing. So that is only the action taken by the hospital, madam. But that is not the action taken by either the Karnataka Medical Council or no other statutory authority. It is only the hospital which has fired. Sir, this question is in continuation.
No, what is the continuation?
Continuation is that the hospital has fired. He has not been asked to stop the practice, but the hospital has fired him.
No, hospital. See,
Hospital is at liberty to do so at any point of time.
See, hospital has the committee. They will take the action, and it is binding on him for the hospital only. Why he should stop if he let him leave the hospital and practice outside?
That he is doing.
Then
Which is
there is no
forthcoming in the question itself, that he is practicing elsewhere, but only the hospital has taken such a stand.
No, let the hospital. Hospital is private body. They have no what is the locus for the hospital. They have removed him from that hospital. There is no order of any authority, either KMC or the commission. No court has held him guilty until that order. He can practice.
We'll end up with this question, sir. Mr. N.C. Mohan, advocate, his question is, sir, what percentile of cases are filed due to misconception of medical complications?
Percentage medical complications.
Misconception.
Hello?
It's filed under misconception.
Misconception.
Yes, sir.
Misconceptions means you mean to say frivolous complaints or what?
Perhaps he has to. I would request Mr. N.C. Mohan to raise his hand so that I can unmute. Mr. N.C. Mohan. One second, sir. I'll just unmute him so that, yes. Yes, I have given you the option. Please unmute Mr. N.C. Mohan.
Yes, Dr. Mohan, yes.
He is not doctor, he is an advocate.
Okay, yes. Tell me. What is the query?
Am I audible?
Yes, you are audible.
Audible.
Sir, good evening. Very nice program, sir. Thank you. My question is, most of the medical negligence cases that I have come across are all filed under the misconception. People don't understand what medical negligence is, and people don't understand that they are the outcome of medical complications.
No, see, the complainant is layman. Complainant is layman, and
Correct.
he won't understand the medicine. His grouse is there is no cure. His grouse or allegation is there was a negligence. He will understand. Now, whether it is frivolous or it is misconception, the court will decide. How can we restrict him, any complainant, to not to file or what? Or that in the admission hearing only, during admission hearing only, the argument should proceed that at the admission stage only the complaint should be dismissed. The commission's duty is they should.
So, in your experience, sir, how many such cases perhaps you would have dismissed at the very threshold?
No, National Commission at admission stage, I have dismissed many cases. Even they approached Supreme Court and affirmed my view. When there is no case at all, why should I trouble the doctor?
So, roughly, sir, what could be the percentage of such cases?
No, percentage, it is difficult because the percentage of total cases or only medical negligence cases, I think nearly 10% cases are by ignorance only. They file by ignorance only. There is no cure. They will file the case.
Right.
The known complications, they will file the case.
Right. So, other limitation is that most of the cases, even the party in person could have filed it without legal knowledge or the consequence.
Party in person, they don't know. They
Correct.
want to harass, they may file the case.
Right. I think by and large, we have taken up most of the questions, sir. I'll just go through if there is any pertinent question. Otherwise, we would conclude today's session.
So thank you very much for patience. So any questions for my improvement? Let me hear any questions.
We have few questions, but two lengthy ones, so it's very difficult to take up those questions. Yes,
Okay.
Sir, by and large, you have addressed all the questions, and before that, it was a very informative and a very insightful session. You have enlightened us on medical negligence and also various facets of Consumer Protection Act. So, we are highly indebted to you.
Thank you,
On
sir.
behalf of Advocates Association Bengaluru, Advocates Academy Bengaluru, and my personal behalf, sir, thank you so much.
Thank you.
I would also like to thank Mr. Krishna Kirtan, my colleague, who has been helping us by sharing the citations. And I would also thank all the participants. Thank you, one and all.
Thank you.
Can we conclude the session, sir?
Yes, sure. Thank you.
Yes, sir. Thank you very much. Good night.
Thank you.